Hi, this is a comprehensive session all about mediation. Starting from the meaning and concept of mediation, we will also discuss who is mediator, who can be a mediator, what are the qualifications of a mediator, what are the roles of a mediator, types of mediation, advantages of mediation, what are the cases that can be mediated, process of mediation, what happens after mediation, and we will conclude this session by giving differential remarks between mediation and litigation. So let's start with what is mediation. Mediation is one of the techniques of alternative dispute resolution or ADR, and ADR is the alternative way and method of resolving disputes outside a judicial process. It means to settle disputes between two or more parties whereby the parties work towards an agreement with the support of a neutral third party. It means to settle disputes between two or more parties whereby the parties work towards an agreement with the support of a neutral third party, that is the mediator. However, the mediator doesn't decide the final outcome of a dispute, but rather he/she only assists the parties in finding the solution. Mediation, therefore, does not form binding agreements unless the parties consent for this. Now, come to the concept of mediation. Mediation is voluntary. The parties retain the right to decide for themselves to settle a dispute and the terms of settlement of the dispute, even if the court has referred the case for mediation, or else if mediation is required under a contract or a statute. The decision to settle and the terms of settlement always rest with the parties. This right of self-determination is an essential element of the mediation process. The benefit of this that the settlement is done by the parties themselves and therefore acceptable to them. Secondly, if they have chosen the mediation process, even in this situation, they have the ultimate control over the outcome of the mediation. Further, any party may withdraw from the mediation proceeding at any stage, even before its termination and without giving any reason. Mediation is party-centered. It means the parties and not the neutral mediator is the focal point of the mediation process. The mediator is a guide who assists the parties to find their own solution to their dispute. Mediator does not give his or her own views, neither makes decisions, but rather he/she works together with the parties to facilitate the dispute resolution process and doesn't adjudicate a dispute by imposing a decision upon the parties. So, his or her role is facilitative. Next, mediation addresses both the factual legal issues and the underlying causes of a dispute. It means mediation is largely focused on the facts, law, and underlying interests of the parties, such as personal, business, commercial, family, social, and community interests. Next, the objective of a mediation is to find a mutually acceptable solution that adequately and legitimately satisfies the needs, desires, and interests of the parties. Next, mediation provides an efficient, effective, swift, convenient, and less expensive facility to resolve their dispute. Next one is the mediator is a neutral party. Therefore, mediator remains impartial, unbiased, and independent throughout the mediation process. In event of the failure to settle the dispute, the report of the mediator does not mention the reason for the failure. Lastly, the mediator cannot be called upon to testify in any proceeding or to disclose to the court as to what transpired during the mediation. Now, come to the who is a mediator. Simply, a person who mediates is known as a mediator. Next, Who can be a mediator? Any judge, advocate, lawyer, psychiatrist, or social worker with great understanding and sense of humor can be a mediator. Besides, a specialist or subject experts such as engineers, architects, doctors, teachers, etc. can also be mediators. However, to become a successful mediator and make a mediation process successful, a formal training is essential, along with the knowledge of their respective fields and subject specialization. Some special and technical skills are required that can be acquired through the training process. Now, come to what are the qualifications of a mediator? Neutrality. A mediator has to be a neutral person. Legally as well as ethically, he or she is not allowed to take sides. Persuasive language. A mediator must have very good communication skills so that he or she can persuade the parties to open up and disclose their mind and heart, their grievances, and the solution they expect for. Legal technical knowledge. A mediator is expected to have the legal and technical knowledge so that he or she can understand the problems and suggest the better solution. Sense of humor. A good sense of humor helps mediator to understand the ground realities and the nature of dispute and assists to make a swift inquiry, that is, asking right questions and replying appropriate answer if any question asked by the parties. Good listener, patience. It is one of the essential skills that is essential for a mediator. As mediation is not one sitting solution, therefore, he/she needs to have patience to understand the problems to help them to reach on a mutually acceptable solution. Now, come to what are the roles of a mediator? Understanding of human nature. This is one of the most important roles of a mediator. He/she has to be skillful enough to understand the psychology of the parties. Only then he/she can help them to make a mutually agreeable decision. To resolve a dispute, mediator has to understand the reason of the dispute and identify the area of the dispute. Besides, he/she also needs to understand the underlying desires, wishes of the parties along with the weak points so that he/she can help them to negotiate better. Maintaining the confidentiality. The parties tend to openly discuss their problems and secrets with the mediator. So the mediator comes to know all the strengths and weaknesses of the parties, which are essentially not to be shared with anyone, even not in the court. A mediator has to maintain the confidentiality of the parties and case. Facilitating the parties. A mediator is required to facilitate or manage the interactions between parties and help them to find the final and desirable solution. Analyzing the issues. A mediator is required to analyze the disputes and other relevant issues. Only then he/she can help appropriately. Maintaining the discipline and decency of proceedings. Discipline and decency are the keys to the success. Therefore, a mediator is expected to maintain the discipline and decency of the mediation process. So, in gist, a mediator manages the interaction between the parties, encourages and promotes communication between them, controls the interruption and outburst by them, and motivates them to arrive at an agreeable settlement. In addition to this, a mediator also evaluates when he/she assists each party to analyze the mediators of a claim, defense, and tell them the possible outcome at trial. Now, come to the types of mediation. Depending on the nature, mediation can be categorized as private mediation, In a private mediation, a qualified and experienced mediator offers his or her mediation services at a private place. Second, court-referred mediation. Under Section 8(9) of Indian Civil Procedure Code 1908, court refers pending cases to the mediation. Now, come to the advantages of mediation. Freedom. There is an absolute freedom in terms of choosing a mediator, time and place of proceedings, or even in terms of choosing mediation to resolve a dispute. Parties have full control. The parties are the authority to decide the final outcome. Participative. Parties have liberty and freedom to present their case in their own way and directly participate in mediation process. Voluntary. It is absolute voluntary, as parties can withdraw any point of time of the proceedings. Swift and flexible. Mediation is a speedy and flexible process, and it can be designed or fixed as per the convenience of the parties. Cost-effective. It is very much economical, that saves not only money but time as well. Simple and efficient. It is very much simple and efficient, that facilitates a win-win situation. Informal. The process of mediation is informal, which is done in a friendly and conducive environment. Fair. Mediation is a fair process, as the mediator is impartial and neutral. Confidential. The mediation process is highly confidential, and no one, even mediator, is allowed to disclose about the process or any secret of the dispute, not even in the court of law. Facilitative. It facilitates better environment, effective communication opportunity to discuss the fundamental issues with full right. Maintaining the friendly relationships. Mediation is a friendly process that doesn't allow any personal animosity to carry forward, as it resolves the animosity during the proceeding itself. Mutually beneficial. Mediation is a win-win situation where both the parties have advantages and no one left unhappy. Now, come to the what can be mediated. The dispute or conflict, normally civil in nature, can be mediated successfully. However, for the convenience, it is categorized into three groups, namely personal family disputes, workplace disputes, and commercial disputes. Personal family disputes include financial or budget disagreements, separation and divorce, alimony, parenting plans, child custody, family property, family businesses, adult sibling conflicts, parents, adult children, elder care. Workplace disputes include discrimination, workers' compensation, wrongful termination, harassment, and grievances. Commercial disputes include real estate, builders, contractors, homeowners, landlord-tenant contracts, medical malpractice, personal injury, partnerships. Now, come to the process of mediation. Introduction and opening statement. This is the first session where mediator and the parties introduce themselves. Secondly, that is joint session. Both the parties have an opportunity to put their concern one after another in a friendly manner. Thirdly, caucus or separate session. In this session, mediator counsels each party separately. Lastly, it is closing. This is the last session in which the final outcome is finalized and drafted, provided if the mediation is done successfully. Now, come to the what happens after mediation. Once the mediation is done, following are the three feasibilities. Both the parties are agreed to accept the final agreement happily. In such a case, mediator drafts the details of the settlement and all the parties sign the agreement demonstrating their willingness to abide by the terms. Second, mediation process did not reach on any final agreement. In such a case, the court is final destination. Third case, though the final agreement is done, but one of the parties fails or refuses to follow the terms, in such a case, legal action can be taken against him or her. Now, come to the litigation versus mediation. Before giving the differential remarks between mediation and litigation, I would like to add that both the terms have their own benefits. Both are advantageous in their places, and both have their own significance. However, for certain cases, especially civil disputes, mediation is better and advantageous to the parties. So now the differences are as follows. Litigation is an adjudicatory or courtroom process where a judge decides the case. Mediation is a negotiation process at private place where a third party, neutral person, supports the parties to make a mutually agreeable final agreement. In litigation, the procedure and decision are governed and controlled by the relevant statutory provisions. In mediation, parties have full freedom and as such no restricted rules need to be followed. In litigation, the decision is binding on both the parties. In mediation, the decision is binding if both the parties happily signed the final agreement. Litigation is adversarial in nature as it focuses on past events and gives a decision based on those past acts and liabilities. Mediation is collaborative in nature as it focuses on present and future and derives the final agreement based on that. In litigation, usually, personal appearance and active participation of the parties are not required. In mediation, personal appearance and active participation by the parties are essential. Litigation is formal proceeding held in a courtroom, usually a public place. Mediation is an informal proceeding in a private place. In litigation, decision is appealable. In mediation, if agreement signed with consent, then it is not appealable. In litigation, there is no opportunity for the parties to communicate with each other. In mediation, the parties resolve their problem with communicating each other directly. Moreover, for many of the civil cases, mediation is the most suitable dispute resolution techniques.